Hello, ladies and gentlemen. I am a professor and the captain Hyeon Kim from Korea University School of Law. I am the director of Korea University Maritime Law Institute. I would like to express my thanks to the Chinese Maritime Law Association for inviting me as a guest speaker. My topic for today is the necessity of international legal regime for cross-border logistics contract. First issue, recently the supply chain for trading goods has been collapsed. The freight for ocean shipping rose very sharply, and the exporters, importers are not able to find space for transporting their goods. The problem came from United States inland logistics. Due to COVID-19, many labor forces were not able to participate in works for moving goods at port area and inland area. The imported cargo became stocked at the dockyard, which made the vessel unable to enter into the port area for discharging. As a result, the vessel should have been waiting for berthing at anchorage. Finally, 12% of the total container vessels all over the world were stopped. As a result, the supply of the vessel became short of the demand for shipping. The absence of a legal regime for international logistics contract drew my attention. Legal regime for maritime leg has been developed successfully. However, there is no international legal regime for cross-border logistics contract. A logistic company may enter into logistics contract with an export. The contract covers from the factory of the exporter to the factory of the import. The logistic company makes several contracts with the parties in order to carry out individual performance, such as warehousing, custom clearance, transportation, stevedoring, and last mile delivery. For example, the company needs to make carriage of goods by sea contract with a liner shipping company for maritime transportation. Even though maritime leg is subject to Hague-Bisbee rule, there is no laws for cross-border logistic contract itself. It is executed only by the contract itself. Because the contractual party is the logistic company is legally liable for damages incurred during the performance of a logistic contract. The compulsory rules may be needed to regulate safe and prompt flow of the goods in the cross-border logistics contract. It can be secured not by the contract but by the statutory laws. Second, what is the cross-border logistics contract? First, look at the carriage of goods by sea contract. The contract for carriage of goods by sea is the most simple type of contract. It covers carriage from a port in exporting country to the other port in importing country. The carrier is liable for cargo damages as per the contract and domestic laws or international convention such as Hague-Bisbee rule. Almost all of commodities are transported by common carriage or carriage of individual goods contract. The carrier in the business is so called as the liner shipping company. Second, the combined transportation contract. The contract for carriage evolved to the combined transportation, under which a carrier undertakes a carriage with two different modes of transportation. The carrier performs maritime leg and the inland leg together under the single carrier's name. There is no need for the shippers to make two different contracts with the two carriers. The shipper is needed to contract only one carrier, which is the one of the advantage for combined transportation. The carrier is liable for all damages incurred during maritime lag and inland or air lag as well. Third, logistics contract. About 20 years ago, logistics contract appears as a new type of business. The export tries to assign all performance from its factory to the importer's factory to one merchant. The coverage includes all services from the moment of manufacturing goods to the moment of the importer's factory. It includes the labeling, warehousing, custom clearance, stevedoring, and the carriage of goods by land, air, and sea, and the last mile delivery. A merchant called as cross-border logistics service provider appeared. It undertook all kinds of individual activities and duties as a whole. It is called as SCM provider or logistic provider. DHL, NYK Logistics, and Alex Pantos is a good example of a logistic provider. Section 3, what is needed for logistic contract? First, freedom of contract. Freedom of contract prevails in the logistic business. The parties' intention in the contract is respected by the court, and thus contractual terms are applicable to the legal dispute between the parties in logistic contract. Under the current freedom of contract regime, the duty of the logistic company is decided only by the contractual terms. One party may delete one of the individual duties of the contract. The extent of damages may be reduced by the contractual terms. The logistic provider may have power to limit its liability to some extent under the contract. A Korean situation, Samdasu case. Korea does not have any rules for regulating a logistic contract. Samdasu case in 2019 by the Korean Supreme Court. The Korean Supreme Court applied the combined transportation contract provision under Article 816 of the Korean Commercial Code. It decided that the core of the logistic contract is the combined transportation. Finally, maritime law was applied by the court to the case. In the case, the original logistic contract between Samdasu and the logistic provider had been cancelled. Samdasu was needed to look for another logistic provider. It incurred additional expenses for Samdasu to retain the another logistic provider. The damages in the case was not cargo damages or delayed damages. The nature of damages which Samdasu incurred as a claimant was totally different from that stipulated in Article 816 of the Korean Commercial Code. As you know, the Korean maritime transportation law regulates only the damages incurred in the goods. In Samdasu case, the damage did not stem from the goods. Thus, damage might be regulated not by Korean maritime law, but by the Korean Civil Code. If that is the case, time bar will be 10 years rather than 1 year under the maritime transportation. In this Samdasu case, Korean Supreme Court stated that because there was no provision regulating logistic contract, it applied combined transportation provision. A necessity for a logistic contract. Under the cross-border logistic contract, the necessity of the international convention is very high. Commodities are exporting and importing globally. Currently, there is no unified single law for regulating logistic contract. Each country's law is applicable. As far as I know, neither Korea, Japan, nor the China have provisions applicable for the logistic contract. It is regulated by the contractual terms. Provisions for cross-border logistic contract. At least several provisions should be provided in the statutory laws for cross-border logistic contract. First, we need to set the extent of the obligation of logistic provider. The basic obligation of the provider should not be contracted out. For example, the duty of transporting commodities under logistic the contract will not be contracted out because it is the core obligation in the logistic contract. The receipt and delivery will be such items which cannot be contracted out. The second, the extent of damages may be stipulated, not limited to the direct damage against the commodity. Damage in delay and additional expenses caused by non-performance of the contract should be included as damages payable. The extent of damages may not be limited to the direct damages. Damage in delay and additional expenses caused by non-performance of the obligor should be included as damages payable. Third, the logistic provider may be allowed to invoke the package limitation just the same as the maritime carrier under the Hague-Visby rules. The obligation of damages to the commodity cannot be identified easily. Even in the case of concealed damage, the logistic provider may have the right to invoke the package limitation for retaining pursuability. The fourth, the time bar provision is needed to be provided. The 1 year time bar will be a good choice. The fourth chapter, relation between the logistic provider and the maritime carrier. Almost all of commodity will be transported by the maritime carrier at sea. What is the legal relation between the logistic provider and the maritime carrier known as the liner shipping company? First, the logistic provider as the obligor. The cross-border logistic provider undertakes several individual obligations such as custom clearance, warehousing, stevedoring, transporting, and the delivery in total. But it cannot carry out whole works in his person. It is usual manner that logistic provider does not own the physical facility such as the vessel, airplane, or truck. Inevitably, it needed to enter into another contract for the carriage of goods by sea with the liner shipping company. The commodities are carried out by the maritime carrier, which is an independent contractor of the logistic provider, because maritime carrier performs one of the duties of the obligor. In this case, logistics provider. The logistic provider will be liable for damage which the export incurred during the maritime carriage. On the other hand, it is also in the position as a shipper against the liner shipping company. It has recourse claim against the liner shipping company when it pays damages to the exporter caused by the negligence of the liner shipping company. Logistic provider has a recourse claim against the liner shipping company. That is the main point. The carriage of goods by sea, house bill of lading, and the master bill of lading. House bill of lading will be issued by a logistic provider to the export. It is used for negotiation purpose. For exporting commodities, liner shipping company will issue the master bill of lading to the logistic provider. The commodity should be handed over to the holder of the house bill of lading with exchange of house bill of lading by the ship's captain or the carrier. The exporter or the holder of the house bill of lading may raise claim against the liner shipping company as the actual carrier based on tort. It is not allowed to raise claim based on the breach of the contract because there is no legal relationship of the contract between them. The liner shipping company will be allowed to invoke the package limitation just the same as the logistic providers enjoy. The last chapter, what is the effect of the International Convention for Logistic Contract? It may give possibility to stakeholders such as export, import, maritime carrier, and the logistic provider. Logistic provider under the new International Logistic Convention will act more cautiously and well prepared than the current situation because they will become to know their duties and obligation in advance owing to the presence of international convention. They will have carrot and the stick to prepare for performing their duty properly because they are needed to pay damages in delay by the statutory law or statutory convention. They may push United States government to maintain a logistic facility more adequately than now. In order to escape paying damages, as a result which the flow of the commodity under logistic contract becomes more smooth. Thank you. Thank you for listening my speech. Thank you so much.